Here's a number that should make every business owner sit up. As of early 2026, industry surveys suggest that a majority of Indian companies still haven't completed a basic data mapping exercise, one of the most fundamental first steps toward DPDP compliance. And the rules notified in late 2025 mean enforcement timelines are no longer a distant concern. So, what exactly does this act require and who does it apply to? That's precisely what this chapter tackles. By the time you finish these lessons, you'll clearly understand the Act's objectives, its scope, and every key term: data fiduciary, data processor, data principal, personal data that forms the vocabulary you'll use throughout the rest of this course. Think of this chapter as learning the grammar before you write the sentences. Get these fundamentals right, and everything from consent mechanisms to penalty structures will click into place far more easily. Let's get started. Alright, let's finally open the Act itself. The Digital Personal Data Protection Act 2023 is India's first comprehensive, dedicated data protection law. But here's something worth appreciating before we dive into clauses and definitions. This act is deliberately short. Compare it to GDPR, which runs into 99 articles across dozens of pages of dense legal text. DPDP, by contrast, is remarkably concise. Why? Because Indian lawmakers wanted something implementable, not just theoretically comprehensive. Simplicity was a design choice, not an accident. I remember a client's general counsel telling me, half joking, "Finally, a law I can actually read cover to cover in an afternoon." That's not usually how privacy professionals talk about legislation. But don't mistake brevity for simplicity in application. Fewer words often means more is left to rules, guidance, and interpretation, which is exactly why the DPDP rules notified later became so important. They fill in operational detail the Act itself leaves open. In this chapter, we'll build your foundational vocabulary. Think of data fiduciary, data processor, and data principal as the three central characters in every story this Act tells. Once you know who's who, everything downstream becomes far easier to follow. Every law has a why behind it, and DPDP states its purpose fairly directly: to protect the personal data of individuals while enabling the lawful processing of that data for legitimate business and governance purposes. Notice both halves of that sentence: protection and enablement. Neither stands alone. Think about what happens when a law leans too heavily one direction. Lean too far toward protection and you strangle innovation. Startups can't function if every data use requires impossible bureaucratic hurdles. Lean too far toward enablement and citizens lose meaningful control. Exactly the harm we discussed back in Chapter 1. I often use this analogy with students. Imagine a busy highway. Traffic laws don't exist to stop cars from moving. They exist so cars can move safely and predictably. DPDP works the same way. It's not trying to stop businesses from using data. It's trying to ensure that use happens safely, transparently, and with genuine accountability. Here's a rhetorical question worth sitting with. Why does India specifically use the word digital in this Act's title? Unlike GDPR, which covers all personal data regardless of format, DPDP focuses specifically on digital personal data. That's a deliberate scoping decision reflecting India's digital-first economic reality, and it directly shapes which organizations must comply and how. Understanding this dual objective, protection alongside enablement, will help you interpret nearly every provision we study going forward, especially when specific clauses seem to balance competing interests. Let's talk about who this Act actually applies to, because the scope is broader than many businesses initially assume. DPDP applies to processing of digital personal data within India, full stop, regardless of whether that data was collected online or offline and later digitized. But here's where it gets genuinely interesting: extraterritorial reach. The Act also applies to processing outside India if that processing relates to offering goods or services to individuals within India. Think about a US-based e-commerce platform with zero physical presence in India, but millions of Indian customers ordering products. That platform falls squarely within DPDP's scope. I worked with a SaaS company headquartered in Bangalore but serving global customers, including thousands within India. Their initial assumption was, we're a small player, surely this doesn't apply to us. It absolutely does. Size isn't the qualifying factor. The nature of your data processing and its connection to India is. There are limited exemptions worth noting too. Personal or domestic use, and processing for research, archiving, or statistical purposes, provided certain safeguards apply. But these exemptions are narrower than most people initially assume. So ask yourself this as we move forward. Does your organization or your client's organization touch personal data of anyone physically located in India in any capacity? If yes, applicability almost certainly extends to you, and everything else in this course becomes directly relevant to your work. Here's something I tell every batch I train. Definitions aren't boring legal filler. They're the actual battlefield where compliance disputes get won or lost. Section 2 of the DPDP Act contains roughly 24 defined terms, and precision here matters enormously. Think about it like assembling furniture without reading which screw goes where. You might eventually force pieces together, but the result will be wobbly, maybe even dangerous. Legal definitions work the same way. Misunderstand one term, and your entire compliance program builds on a shaky foundation. I once reviewed a company's privacy policy that used consent and notice almost interchangeably, as if they meant the same thing. Under DPDP, they absolutely don't. Notice is information given to the data principal. Consent is their affirmative agreement after receiving that notice. Confuse the two, and your consent mechanism could be legally defective. Rather than reading through every single definition mechanically, which frankly makes for painful training content, we're going to focus on the terms that actually drive compliance decisions in practice. Data fiduciary, data processor, data principal, personal data, and digital personal data. Master these 5 terms deeply, and you'll find that most of DPDP's operative provisions become significantly easier to interpret correctly. Let's take them one at a time, starting with the entity carrying the heaviest legal burden under this Act. Let's talk about the entity carrying the heaviest legal burden under DPDP, the data fiduciary. In simple terms, this is any person or organization that determines the purpose and means of processing personal data. Basically, whoever decides why data is collected and how it will be used. Here's an analogy that clicks for most students. Think of a data fiduciary like a trustee managing someone else's property. You don't own the data outright, you're entrusted with it, and that trust comes with serious responsibility attached. Consider a food delivery app. It decides to collect your address for delivery purposes, your phone number for order updates, and your payment details for transactions. That app is the data fiduciary. It made those decisions, not you, not some external vendor. I worked with an HR tech startup once whose founder insisted, "We're just a small platform. Surely the big obligations don't apply to us." But size has nothing to do with fiduciary status. Whether you're a 5-person startup or a billion-dollar conglomerate, if you determine the purpose and means of processing, you're a fiduciary with full accountability under the Act. Why does this matter so much? Because fiduciaries carry the primary compliance burden, notice requirements, consent management, security safeguards, breach notification, all of it lands squarely on their shoulders. Everything else in this course essentially describes what fiduciaries must do and how they must do it correctly. Now let's introduce a related but distinct character, the data processor. This is any person who processes personal data on behalf of a data fiduciary. Notice the key phrase there, on behalf of. Processors don't decide why or how data gets used. They simply execute instructions. Think of it like hiring a caterer for a wedding. The caterer prepares food exactly as instructed, quantities, menu, timing, but they didn't decide to host the wedding in the first place. That decision and the responsibility for the event belongs to whoever's getting married. A cloud hosting company storing customer data for an e-commerce platform is a classic processor example. They store and manage the data, but the e-commerce platform decided what data to collect and why. That distinction matters enormously for liability. I recall a client, a payroll processing vendor, who assumed they carried zero compliance responsibility because they were just following client instructions. That's a dangerous misconception. While primary obligations sit with fiduciaries, processors still carry real contractual and security responsibilities, and fiduciaries must ensure their processors handle data appropriately. So here's a useful test moving forward. Ask yourself, who decided why this data is being collected? If your organization made that call, you're likely a fiduciary. If you're simply executing someone else's instructions, you're probably operating as a processor instead. Every privacy law ultimately exists to protect one party, and under DPDP, that's called the data principle. Essentially, you and me, the individual whose personal data is being processed. This term deliberately replaces the more passive-sounding data subject used in laws like GDPR. Think about that word choice for a moment. Principle, not subject. A subject sounds like someone data happens to. A principle sounds like someone with agency, someone in control. That's not accidental language. It reflects the Act's underlying philosophy that individuals should remain active participants in decisions about their own data. Here's a real scenario. When you sign up for a fitness app and it asks for your health data, heart rate, sleep patterns, workout history, you are the data principal in that relationship. The app is the fiduciary. Everything the Act requires, notice, consent, the right to access and correct information, exists specifically to protect your position as principal. There's an important addition worth noting. When the data principal is a child under 18, their parent or lawful guardian exercises these rights on their behalf. We'll explore this in much greater depth later, since children's data carries heightened obligations. Understanding the data principal's central role reframes how you should approach every compliance decision going forward. Ask yourself constantly, does this practice genuinely respect the principal's control over their own information? That question will guide you through far more of this Act than you might expect. Let's define something that sounds obvious, but trips up more professionals than you'd expect. Personal data. Under DPDP, personal data means any data about an individual who is identifiable by or in relation to such data. Notice how broad that phrasing actually is. Here's where confusion often creeps in. People assume personal data only means obviously sensitive things, medical records, financial details, biometric information. But think about a simple delivery address combined with a name. Individually, maybe not alarming. Combined together, that's absolutely personal data because it identifies a specific person. I once reviewed a marketing team's data inventory where they'd excluded just an email address from their compliance mapping, reasoning it wasn't sensitive enough to worry about. That's a fundamental misunderstanding. An email address alone, in most contexts, absolutely qualifies as personal data because it identifies an individual. Think of it like a puzzle. Each piece, a name, a location, a device ID, might seem harmless alone. But puzzle pieces combine to form a complete picture of a person, their habits, preferences, movements. DPDP's definition captures data at exactly that identifiability threshold, not just obviously sensitive categories. So here's a practical habit to build starting today. Whenever you are unsure if something counts as personal data, ask one question. Could this reasonably help identify a specific individual, alone or combined with other data you hold? If yes, treat it as personal data, no exceptions. Finally, let's narrow our focus to the specific scope DPDP actually governs: digital personal data. This means personal data that exists in digital form, either collected directly online or collected offline and subsequently digitized. Here's why this distinction matters enormously. Unlike GDPR, which covers personal data regardless of format, paper records included, DPDP deliberately limits itself to the digital realm. Think about a doctor's handwritten prescription pad sitting in a physical filing cabinet, never digitized. Under DPDP alone, that paper record technically sits outside scope. But here's the twist that catches people off guard. The moment that same prescription gets scanned into an electronic health record system, it instantly becomes digital personal data, and DPDP applies immediately. I worked with a healthcare client transitioning from paper to electronic records, and this exact transition point became a critical compliance milestone we had to plan around carefully. Think about how much of India's economy has already gone digital: banking, healthcare records, retail transactions, government services. Even though DPDP's scope sounds narrower than GDPR on paper, in practical terms, it captures the overwhelming majority of personal data flowing through Indian businesses today. So here's a forward-looking question worth considering. As your organization digitizes more processes, forms, records, workflows, does your compliance program keep pace with that expanding digital footprint? That's precisely the mindset DPDP expects fiduciaries to maintain continuously, not as a one-time exercise. Let's consolidate Chapter 3. We opened the Act itself and saw its dual objective: protecting individuals while enabling legitimate business use, a balance reflected throughout every provision we'll study. We explored applicability, discovering that even foreign companies serving Indian customers fall squarely within scope, regardless of physical presence. We then built our core vocabulary, understanding data fiduciaries as the accountable decision makers, data processors as the instructed executors, and data principals as the individuals this entire act exists to protect. Finally, we distinguished personal data from its narrower cousin, digital personal data, and saw how India's digitizing economy makes that distinction matter less in practice than it might first appear. These 5 terms, fiduciary, processor, principal, personal data, digital personal data, form the vocabulary foundation for absolutely everything remaining in this course. If you want a fully structured version of this journey, complete with role plays, scenario-based quizzes, and practice tests, check out our complete course, DPDP Act Compliance Masterclass, on Udemy, linked in the description below. Also, subscribe so you don't miss what's coming next, and click on the DPDP Act Master Series playlist in the description for the complete sequence. Next up, we open the Act's actual legal text, starting with chapters 1 and 2. See you there.